Honorable Senators, I rise today to speak to my bill regarding the repealing of mandatory minimum penalties and upholding the coveted sentencing principle of judicial discretion. Avant de vous exposer.
Before giving you the reasons explaining why this bill is so crucial, I would be remiss if I did not begin by thanking from the bottom of my heart Senator Pate for having carried the torch for this bill and for so many other causes.
I want to thank you for your exceptional work around these issues and for helping me draft this bill. Senators, I viewed Senator Pate in prisons, and I tell you that prisoners across the country look to her to protect their rights. She has built such credibility on these issues that they look to her to make sure that she will be there to speak in the Senate to protect the prisoners' rights. Senator Pate, I'm in real admiration of your work, and thank you for your work. Yeah. In spite of their name, mandatory minimum penalties are in direct contravention of judicial discretion. A one-size-fits-all, the cookie-cut approach to sentencing, such as mandatory minimum penalties, destroy the ability of judges to determine appropriate sentences based on individuals' particular circumstances. Honorable Senators, it is easy for us to make laws we believe are right in the warmth of this chamber. We make laws we believe will benefit society, and yet most of us, do not see the people who are most impacted by these laws. The judges across the country do see these people. They come to know their circumstances, the circumstances in which they base the judicial sentencing principle. Every day, the judges see their faces when they're making a decision about whether or not to send a person to prison and for how long. In their current form, mandatory minimum penalties tie a judge's hands. They give them little other options than to look at the person in the face and sentence them without sufficient consideration of their circumstance. We parliamentarians, without knowing these individual cases, have decided that their sentence is against sentencing principles. In doing so, we parliamentarians are directly preventing judges from doing the job they were appointed to do. The bill that I have in front of you, in summary, is it basically says it allows a court to decide to not make a mandatory prohibition order provided for under a provision of that act, or to add conditions or vary any conditions set out in that provision, if the court considers it just and reasonable to do so. It requires the court to provide its reasons for making such a decision.
Moreover, the imposition of mandatory minimum sentences automatically ignores aggravating and mitigating circumstances.
Mandatory minimums undermine the founding principles of sentencing outlined in Section 718 of the Criminal Code. Namely, the fundamental purpose of sentencing is to protect society and to contribute, along with crime prevention initiatives, to respect for the law and maintenance of a just, peaceful, and safe society by imposing just sanctions that have one or more of the following objectives. Close quotations. As many of you know, I have long been an advocate for importance of judicial independence. A cornerstone of independence rests on the ability of a judge to use their discretion and determine the correct ruling in the matter they are tasked with adjudicating. Honorable Senators, those of you who have been in this place for some time will also know I've always been in support of addressing the injustices which persist due to mandatory minimum penalties. I have introduced a bill not once, not twice, but 3 times regarding the use of mandatory minimum penalties. In June of 2013, I introduced Bill S-213, an act to amend the criminal code, exception to the mandatory minimum sentences for manslaughter and criminal negligence causing death. In November of 2013, I introduced a bill S-209 of the same name. In February of 2014, I once again introduced Bill S-214 with the same name. Comme l'exprime clairement.
As the titles of the 3 bills make clear, my intention was to address the imposition of mandatory minimum sentences in relation to the changes for manslaughter and criminal negligence causing death. I know now that I did not go far enough.
Senators, that was then, and this is now. I now realize that I should have had a more extensive bill. Last parliamentary session, the federal government introduced Bill C-22, an act to amend the Criminal Code and the Controlled Drugs and Substances Act. The bill marked a step forward in that the government was at last acknowledging the failures of mandatory minimum penalties and seemingly committing to moving fast their routine use. Despite these very commendable efforts, the bill did not go far enough. Rather than taking a clear stand against all mandatory minimum penalties and thus wholly reinstating judicial discretion, the bill simply repealed 19. The number is even more inadequate when you consider with the fact that to date at least 43, I repeat, Senators, 43 mandatory minimum penalties have already been struck down by the courts at all levels throughout this country. And as I speak, the courts continue to rule mandatory minimum penalties unconstitutional and disproportionate in how they are applied, with an emphasis on how they reinforce systemic racism. Honorable Senators, as we all know, when hearing bill titles, speeches, and political rhetoric from all sides, and in both this and the other place, it can be easy to lose sight of the human beings at the forefront of every issue we face and every decision we make. In fact, when it was first tabled in the other place, I was very supportive of Bill C-22, and I argued with some of you that let us encourage for this bill to go through, as it's important we have something in place. It was important that we have some kind of government acknowledgement in place. I saw it as a step forward, and I still do. That said, we know that the government is planning to reintroduce a bill regarding mandatory minimum penalties. Before they do, Senators, we now have a chance to send a very strong message to the government that this bill, by sending this bill to the other place, we can send a message that this time we will not just accept a tick mark. We will not accept going 1/4 or even halfway on this issue. Senators, we have the opportunity to tell them the time is now to restore judicial discretion and to ensure justice is upheld for all people in Canada. Honorable Senators, this bill is so important because flawed legislation directly impacts lives. Le plus souvent, ce sont
More often than not, the people who are most left behind and forced to find ways to survive are the ones with whom the law comes into conflict.
You may have heard of the story of Cheyenne Sharma, a young Indigenous girl. At the time of her sentencing, Cheyenne was 23 years old and a single mother. Cheyenne's grandmother is a residential school survivor who was impregnated at age 13. Her mother was caught in the grips of the foster care system. When Cheyenne was just 5 years old, her father was deported to Trinidad. Cheyenne first ran away from home at 13 years and 15 years old. Consequently, she was forced to begin prostituting herself. She said the reason was because she needed the money to pay rent as she was facing eviction. Senators, at 13 and 15. Honorable Senators, I ask you to think for a moment about our own children. Where were they at 13 and 15 years old? What were they doing? Were they in school? Were they playing their favorite sports? Did they spend a lot of time out having fun with their friends? Cheyenne did not have the opportunity to do any of these things. By age 17, Cheyenne had attempted suicide multiple times.
From the moment she was born, Cheyenne found herself in circumstances entirely beyond her control.
Honorable Senators, mandatory minimum penalties do not allow a judge to consider any of Cheyenne's circumstances, only that she committed a crime. Thankfully, in this instance, the Ontario Superior Court Justice Casey Hill, who was presiding over her case, concluded that the mandatory minimum sentence of 2 years, which he was being tasked with imposing, and I quote, would outrage standards of decency. I repeat, the judge said, would outrage standards of decency and would violate Canada's Charter of Rights and Freedom. In Cheyenne's all too rare instance, a semblance of justice prevailed. However, Honorable Senators, we cannot leave the balance of justice to lean on the goodwill of some well-meaning and compassionate judges. Honorable Senators, I really wish this was a precedent-setting ruling, but it is not. Unfortunately, other judges across the country are not bound to follow this Justice Hill's stellar example. Far too often, this is not the end result. Over the summer, I was very shaken when I accompanied Senator Pate and saw firsthand the realities of prisons in Canada following 2 years of the pandemic. There is a conception around society that prisoners are very well treated. Well, Senators, I did not see that. I was also most outraged by the disproportionate numbers of racialized men and women in maximum security prisons.
At Fraser Valley Institution for Women, inmates are rated from minimum and medium to maximum security.
Staff inside the prison's gymnasium. We were told that 61% of prisoners and 89% of those classified as maximum security are Indigenous women. This is yet another example of the overrepresentation of Indigenous peoples, in particular of women in prisons across Canada. We also visited Kent Institution, the only federal maximum security prison for men in the Pacific region. When we arrived, we were met with the senior staff at the prison who informed us that out of 240 men inside, 88, about 1/3, are Indigenous, and 22 are Black. I would like to remind you all that Indigenous people represent less than 5% of our entire population. We also learned that some prisoners feel the prison has created a racist and toxic environment. This is another reminder of the racism and discrimination that happens behind prison walls every day. Honorable Senators, these people are suffering and very few people are listening. When the length of their sentence is blindly decided by mandatory minimum sentencing legislation we pass, it should not be considered a punishment. It is sheer cruelty. It follows that according to the Office of the Correctional Investigator, indicate that 30% of all federally sentenced prisoners and 42% of federally sentenced women are indigenous. This rate has increased by 43% since 2010. During the same period, rates of non-indigenous incarceration decreased by 14%. The Office of the Correctional Investigator pointed to the ongoing failure of the criminal legal system to respond to needs, histories, and social realities of indigenous peoples at the root of these high rates of criminalization. There is a further problem with mandatory minimum penalties. It makes it impossible for the court to follow Section 718.2e of the Criminal Code to ensure GLADU factors are taken into account. Fundamentally, GLADU principle ensures judges account for the fact that indigenous people rarely have the same access to justice as non-indigenous people, which often impacts the outcome of their cases. GLADU also pushes judges to act with increased awareness with regard to their legal matters and, if applicable, their sentencing. Well, honorable senators, how can the judges look at this if they are bound by mandatory minimum principles? For clarification, GLADU principle means a judge must consider, and I quote, a person's community perspective on the situation, their needs, their suggested alternatives to jail. Their community can be an indigenous community where they live or come from, but it also extends to their support network or the people they interact with. If they live outside an indigenous community and aren't connected to one, they still have a community. The laws, practices, customs, and legal traditions of their nation or the nation where the alleged offense took place. Decisions must be based also on sensitive and appropriate to the person's culture, close quotations. Ultimately, the principles aim to account for documented daily and seemingly routine injustices faced by indigenous people within the justice system. Accordingly, this bill is directly aligned with the calls to action of the Truth and Reconciliation Commission and the calls for justice of the National Inquiry into Missing and Murdered Indigenous Women and Girls. In 2015, the government's election platform included a promise to implement the calls to action of the Truth and Reconciliation Commission. In 2019, the Minister of Justice's mandate letter reiterated the need for progress towards this goal and toward implementation of the calls for justice of the National Inquiry into Missing and Murdered Indigenous Women and Girls. Both demand that minimum sentences be remedied. Echoing this sentiment, the federal government itself noted that the percentage of indigenous people imprisoned federally due to a mandatory minimum penalty has almost doubled in the last 10 years. 39% of all Black and 20% of all indigenous federal prisoners have been convicted of a crime which carries mandatory minimum penalty. Honorable
Senators, how can we expect people to safely and satisfactorily reintegrate into our communities when we keep sending them back behind bars for longer and longer periods of time without addressing the circumstances that put them there in the first place?
To date, Canadian courts have found a significant number of minimum penalties invalid on such grounds. Nearly half, some 31 of the 72 minimum penalties currently in force have been found unconstitutional by at least one court. Of these, about 25 mandatory minimums have been struck down as invalid in various provinces. In 11 cases, a court that struck down the mandatory minimum was a Court of Appeal or the Supreme Court. In 2016, in Lloyd, the Supreme Court drew attention to Canada's precarious position with respect to mandatory minimums and called on Parliament, and I quote, to build a safety valve that would allow judges to exempt from the application of minimum penalties outliers for whom the mandatory minimum will constitute cruel and unusual punishment. Senators, I repeat what the Supreme Court of Canada has said. It will constitute cruel and unusual punishment. Without legislation such as this bill before you all, mandatory minimum penalties have to be challenged one by one before the courts, tying up significant court and government resources and requiring individual Canadians to shoulder the heavy burden of mounting constitutional challenges. In too many cases, those facing a potential unconstitutional minimum simply do not have the means to defend their rights. At the same time, for those with the most resources, mandatory minimum penalties allow for and even encourage drawn-out legislation, including constitutional challenges. An individual
has nothing to lose and everything to gain by going to court and carrying out all the maneuvers suggested by his or her lawyer to save him or her from heavy penalties rather than opting for a quick settlement.
Honorable Senators, you may remember the report of the Standing Senate Committee on Legal and Constitutional Affairs on court delays identifies the strain that mandatory minimums place on scarce judicial resources and pressing issue of trial delay. During the study, at least 11 different criminal justice experts singled out minimum penalties as a factor contributing to overall delays and inefficiencies in the court system. Worse yet, such principles are in sharp contrast to what occurs in cases where mandatory minimum penalties are applied. Mandatory minimums often shift discretion from judges to other actors with virtually no accountability either to the public or to the appeal process. Honorable Senators, those other actors are us. For instance, Crown prosecutors are often tasked with determining what charges to lay and whether to pursue a mandatory minimum penalty. Far too often, their reasons have little to do with legal principles. In some instances, these powers are used as bargaining chips to encourage a person to plead guilty to lesser charge than risk facing mandatory minimum penalty if they are convicted for a more serious one. Honorable Senators, today we have an opportunity to send yet another clear message that we do not support this flawed approach to federal sentencing. This bill will provide judges with a long overdue alternative to imposing mandatory minimum penalty. In fact, it provides judges an unfettered ability to exercise their expertise when determining whether or not it is appropriate to apply mandatory minimum penalties. In doing so, it ensures judges are freely able to not impose a mandatory minimum penalty, in particular when doing so is determined to be inappropriate or unjust. What this bill does not do is give judges a golden ticket to act unfairly or arbitrarily. In fact, the powers this bill aims to equip judges with are not new and are in line with the Criminal Code. As many of you will know, Section 726.2 of the Criminal Code clearly states, and I quote, "When imposing a sentence, a court shall state the terms of the sentence imposed and the reasons for it, and enter those terms and reasons into the record of the proceedings. It follows that all judges are required to give reasons for their sentencing decisions. In addition, their decisions must be rooted in legal principles and are subject to scrutiny from the general public, the legal community, and other judges through appeal processes. Honorable Senators, I know these principles of transparency and fairness are ones which we will take seriously. The bill intentionally does not go so far as prevent judges from imposing minimum sentences. It would simply add a requirement that judges must reflect on and provide justifying and fairness of imposing mandatory minimum sentence. In 1987, the Canada Sentencing Commission found that 9 in 10 judges concluded that mandatory penalties had interfered with their ability to render a just sentence. Also in 1987, when there were 10 mandatory minimum penalties and their approach was deferred to far less frequently, still 57% of judges approved of their use. They went so far as to state that their use inhibited their ability to determine fair and appropriate sentences fitting of the circumstances surrounding the crime. Since then, the issue continues to worsen. In the decades since, the use of mandatory minimum penalties in Canada has continually grown at an alarming rate. This bill follows the experts' lead by allowing judges to not impose a mandatory minimum penalty. Alors, je vous demande
So I ask you all to reflect on this matter. Honorable Senators, what are we waiting for?
Canada can and should be contrasted with the experiences of other democratic states, whose laws include mandatory minimum penalties. Many, including England and Wales, New Zealand, South Africa, Australian jurisdictions, and even a number of US, have taken steps to ensure the integrity and constitutionality of their laws and the rights of their citizens by allowing some form of judicial discretion. In most cases, the judicial discretion extends to even the most serious life sentences. Honorable Senators, I want to share with you the words from a man at William Head Institution in my province of British Columbia, who I had the privilege of speaking with past summer. He told me the way the federal prison system functions is churning out broken people. I cannot get rid of those words out of my head. Churning out broken people. We now have an opportunity to change this long-held course. Senators, when I was a young defense counsel, I often went to court with my senior partner, the Honorable Mr. Doan, who used to be a judge before he retired. And he always used to teach me this, that when a judge sentences somebody, he has to balance everything. He has to balance what kind of person will return to society. Because he always used to say to me, we do not throw the key away. Sooner or later, those prisoners will be released, and they will have to be reintegrated into societies. Senators, I ask you, with the system we have at the moment, when a prisoner from William Head said that we are churning out broken people, is this the right system? Je m'interroge sérieusement à savoir.
I seriously question whether we are accomplishing anything that will actually prepare prisoners for reintegration into society. Honorable Senators, I urge you to join me in opposing unnecessary mandatory minimum sentences and defending judicial discretion.
Senators, we are supposed to look after the most marginalized people. The time is now for us to stand against this injustice. The time is now to stand up for true fairness and equality for all. The time is now to move forward together. I hope, Senators, you will give this bill serious consideration. Thank you. Merci.
Thank you.